matter of Lapoya and versus Willis et al. If counsel could please announce for the record.
Yes, good morning, Your Honor. Jeffrey Gill for the plaintiffs.
Thank
And
you.
Megan
And
St. Thomas for the plaintiff.
thank you and good morning.
Good morning, Judge. Kate Courtroom for defendants.
Thank you and good morning. The court set this status conference to talk about the status of the case and talk about next steps. The court did receive the joint status report that was filed yesterday, I believe, and the scheduling order that was filed some months ago. I wanted to hear from the parties before the court provided some of its own thoughts regarding the status of the case. Mr. Gill or Ms. St. Thomas?
Yes, Your Honor, thank you. My thoughts are it seems like the only issue regarding setting a trial is defense counsel's concern about getting expert depositions and discovery completed, which is at page 2, lines 20. And I'll let Kate speak for herself, but I think we can strike a balance. The court knows our concerns about our client's condition, increased mortality rate, and age. We'd like to get this case scheduled for trial. The concern is that we've experienced all these cases. If we wait to settle trial date is exponentially delayed in the future. A way to strike that balance in this case is we would like the court to settle trial date, especially given this is a very streamlined case, needing only 4 days for our case, defense counsel needing 4 days for their case, that we're happy to stipulate to extending the deadlines leading up to trial, including the expert deposition deadline and completion for discovery, especially with the expectation that this court probably isn't going to have availability any sooner than late spring of 2027, and that's, to me, probably optimistic. But that's our position, pending any question of the court, Your Honor.
Thank you, Mr. Gill. Ms. Corcoran.
Yes, Your Honor, I do have concerns about getting it done in time, and plaintiffs have been very aggressive about keeping the deadlines. So if that's why I put that into the joint report, to kind of put everybody on notice about what I've got going on this fall. And then it's always difficult during the holidays to get experts ready and to travel. But if what Mr. Gill is saying is that he'll be amenable to, moving some of these, it might affect the dispositive motion deadline for this court, though. That'll be the only issue I could foresee. But I guess at this point, I don't even know what your first availability is or on your trial calendar for 8 days, or how you typically set trials. But I guess, I have, well, I don't know. That's that's my input, Judge, I suppose.
All right, thank you. So it does look like, based on the report, that the case is moving. The depositions of plaintiffs and defendant have been completed. The expert disclosures have occurred. The court had some concerns. So I think I may have discussed this before. I may not have with on this case with these counsel. The court typically has 2 prerequisites to set trial. One is that the parties have done mediation. 2, that the parties have completed discovery. Neither has happened in this case. I see in the joint statement that there's a November 6th mediation deadline, but the court hasn't received anything that mediation has even been set. Has mediation been set?
No, not yet, Your Honor.
Okay, when can that be set?
We have availability in November, December, depending on the mediator. That's going to be one of the driving forces getting into a mediator. We haven't discussed mediators yet, but we could get the case into mediation. And it also depends on the defense and what they need prior to mediation. But we can get this case into mediation before the end of the year.
Yeah, I think we could get mediation done before the end of the year as well. And I'll need to have, we haven't finished expert disclosure. Rebuttals are coming up. The rebuttal, which I think technically rebuttal deadlines are due in 10 days. However, just 2 days ago, I finally got the transcript from my doctor. So I'm going to try and make that date work. But without that transcript, it's hard to do rebuttal opinions. In any event, I think by the end of the year, yes, we could likely get mediation accomplished.
All right. So can the parties set mediation by, say, in 2 weeks? Not have mediation, but set mediation, so that the court has some assurances that this matter is moving forward. I guess I I want to try to, I've had numerous hearings. It sounds like there's another discovery dispute that may be brewing in this case. If I'm getting my joint status reports, keeping my joint status reports straight, because I've had a number of hearings this morning. But as I understand it, there may be another cause that the court may have to see the parties. Is that correct?
Yes, Your Honor.
So why don't we do that? Yeah, go ahead.
I apologize, Your Honor. As to what defense counsel had said, Ms. Corcoran had said, difficulty meeting that rebuttal deadline. We can also stipulate to extend the rebuttal deadline. Extending the deadlines isn't a concern for us because we have so much flexibility then in scheduling the depositions of the experts in the mediation, and it's not expert intensive. So we could also extend the rebuttal deadline. But to answer your question, we can get this mediation scheduled on the books within the next 14 days.
Okay. So why don't we call it by September 4th? Does that work for the parties? That the parties can secure a mediation date, and file a joint notice identifying the mediator and confirming the mediation date by no later than September 4th. Does that work for the parties?
Yes, Your Honor.
It should be, Judge. With medical malpractice, the physicians always hold a consent to settle clause, so I have to make sure. I'll be in contact with my client. He's just a very busy neurosurgeon, so sometimes it takes a lot to figure out his schedule. But since we're looking at mediation so far in advance, I think I could probably get it done by that date.
All right, very well. And then, I took some notes. Is the potential discovery dispute regarding health insurance documents?
Yes, I've requested authorizations to get records from Medicare and plaintiff's health insurance. I did send my portion of the discovery dispute over to plaintiffs. I think they were planning to have their response or their portion to me by the end of the day. So perhaps we could just set a hearing here today on our calendars so that we can get that decided.
Let me wait until it's filed, so I'm just trying to think ahead. So maybe what do the parties' schedules look like there? I mean, because maybe the parties can set mediation by the time of that, if the parties need a discovery dispute hearing, by the time of that discovery dispute hearing, so that I don't have to bring the parties in twice in rapid succession. So maybe the parties can. I'm just trying to think. So if the parties need the court's time to resolve their discovery dispute, and the parties are requesting the court's time after mediation has been secured to talk further about a trial setting, I'm wondering if those two dates can be combined. But I'm just kind of thinking out loud here. So I guess what the court's asking is, can the parties work more quickly to try to get the mediation date set so that the court is at a posture where at least a mediation date has been set, so the court can more substantively talk about its schedule for trial at the same time that it hears the discovery dispute.
So is the court's, or so are you resetting a hearing coming up to discuss when mediation is set so that you can determine a trial? Is that
I guess that was one thought the court had, but I guess it doesn't have to be that way. I'm trying to minimize I'm trying to be efficient with the parties' times. I've seen the parties quite a bit already in this case, so I don't want to unnecessarily have two hearings when one will do.
I don't know. That'd probably be fine if you want to set another status conference and the discovery dispute in the, I guess that would be the week of, oops, hold on. All right, so you're looking at the week of September 7th then?
Unless the parties can get the mediation set earlier, I guess.
Got it. Well, I would have available on September 11th.
That date may be bad for the court has a lengthy trial, I think 3-week trial. I think starting that day, or the jury review may be that day, so I may have limited availability.
Okay. We could set it for September 4th, and then we should know by September 4th if the mediation is set or not.
Mr. Gill, does that work?
It does, Your Honor.
Okay, let me see if the court has any availability on September 4th. Ms. Hanson, does the court have availability on September 4th?
Yes, Your Honor, we could do 9 a.m. that day.
It looks like 9 a.m. would work on September 4th.
It works for me, Judge.
Mr. Gill.
Yes, Your Honor.
All right, so the court will hear the discovery dispute and discuss further the party's progress and whether it's appropriate to consider setting trial. Although again, it's unusual for the court to set trial when discovery hasn't occurred or discovery hasn't been completed and mediation hasn't been completed. I want to try to accommodate the parties, but I just want to make sure that expectations are in check, that the court doesn't want to. I guess I need to see a little bit more progress on the case before the court's going to set trial. Anything else that the court can assist with at this time?
Nothing from the plaintiffs, Your Honor, but I do want to mention thank you for accommodating our schedule and plaintiff's request to try and accelerate this. It is appreciated.
All right. Anything on your end, Ms. Corcoran?
No, Your Honor.
Thank you to all counsel for your time and for your efforts. The court will, unless the parties are able to resolve the discovery dispute and the parties can notify the court of that, then the court will plan on seeing the parties back here on September 4th. Thank you.
Thank you.